We are honored to be joined by someone who's going to make us all a lot smarter. You have heard my amateur, stupid legal analysis. Now we get a man who is the legal expert for Sportico. You can read him there, and please do. He is a professor of law at the University of New Hampshire Law School. He is a visiting professor at Harvard University, which I hear is the Harvard of Cambridge, Massachusetts. Michael McCann, how are we doing?
Doing great, Andy. It's great to see you again. I remember our days together, working on a bunch of stories, so it's nice to reconnect with you.
So for those who don't know, Michael and I worked together at Sports Illustrated, and I would just pepper him with questions anytime there was a legal issue involving college sports. And he was getting very tired because he was dealing with the NFL stuff and Major League Baseball legal stuff. And so I'm just sending in all this Byzantine stuff about the O'Bannon versus the NCAA trial. So you ended up writing a book about that, though, right?
I did, yeah. And I got to work with Ed on the book, but the trial, you, me, Stuart, a bunch of us were involved with that coverage, and those were some good days.
Oh yeah, that was fun in the courthouse watching Mark Emmert get grilled, and but now it's your life is just being consumed by all this college stuff. I mean, I don't think there's room for any of the pro sports right now. We got to ask you about all the things that are going on. So I'll start. I guess I'll just go chronologically. Basically, we'll start with the most recent thing, and that is the judge in the Eastern District of Tennessee in federal court denies a temporary restraining order that the Tennessee and Virginia AGs had sought against the NCAA, but this is a case involving the NCAA's NIL rules. But in the order denying this temporary restraining order, the judge basically goes, but the NCAA is going to lose the case. Yep. Is that normal where a judge just says, here's how I'm probably going to rule?
Sometimes judges are more subtle about that. This one was pretty blunt, and maybe I think the judge knows that this is a case that the public is following closely and that he wanted to write it in a way that made it unambiguous how he feels. And he's also telling the NCAA, look, you win this battle, but you're going to lose the war, so figure something else out. And the sort of bluntness in which he wrote, that is not super rare, but uncommon. And he left no doubt that he thinks NCAA restrictions on NIL in the context of using NIL to recruit is illegal under antitrust law. He didn't buy any of the NCAA's arguments. The only thing he bought was that money damages can later make up any damage, so there's no irreparable harm. But the core of the case, he clearly sided with Tennessee.
Well, and it's interesting because we've seen a lot of these cases, and this is not necessarily a case where they have to hold a jury, hold a trial, hold a bench trial or anything like that. So it's not like the O'Bannon case where that took years and years. There's a hearing next week. How long could it be before this judge says, okay, as I said before, I'm going to declare these illegal. Now they're illegal.
Well, I think he'll probably signal how he feels while on the bench. So he'll probably give some sort of indication, but more likely in terms of the actual order, it will come in a written order that could be written. It's up to him, but it could be written some days or weeks after the hearing. But I think it's going to be tough for him to walk back what he wrote in that order to sort of now suddenly say, oh, but now I see what the NCAA's arguing. I mean, he really just repudiated the NCAA's arguments. Didn't to me leave much room for the NCAA to kind of come back in this game, if you will.
Well, and this is not a case where the NCAA can come up with some novel defense because they've been defending these things over and over and over again. They would have, if they had that weapon in their holster, they probably would have pulled it already, right?
Yeah, I mean, I think the NCAA, look, they've had a tough patch, right? I mean, they have not had a winner in a while, and other than the Booley brothers case in Illinois, where they actually did get a win involving the twin brothers who played in overtime elite, but that's the anomaly. The other cases have all been losers for them, and Andy, the big thing, if I were the NCAA, I'd be worried about. It's not as if it's sort of liberal judges are against you, conservative judges are with you, or vice versa. They're all against you.
Yeah,
this is like, I don't know who the audience is anymore so many things in law you can predict. Oh, that's a conservative
Mhm.
judge. That's a liberal judge.
Right.
Not anymore. With this stuff. This is just like they're all ganging up.
Yeah. And we don't get too political on this show, but in this case, it is germane to the subject. And that was what I found interesting in the Alston decision in the Supreme Court, in that you had Neil Gorsuch, maybe the second most conservative justice, writing the majority opinion, and then Brett Kavanaugh, probably the most conservative justice, writing the just blowtorch concurring opinion. And I had spent all this time talking to athletic directors and people, in the business. They thought the conservative folks were going to be the ones on their side. And I always asked them, I'm like, you do realize you're trying to keep markets closed. Like, they don't like that.
Right. Yeah. I mean, I think they thought, and what does a conservative mean in this context? I think the NCAA thought conservative means keep things the way they are, right? Just kind of
Yeah.
romanticize college sports, that kind of describe it as from 1945 or whatever, some sort of the old days of the regatta, and this sort of romanticizing of college. That the justices, at least in this context, are really libertarian, like you just said. They find these rules so constraining. Justice Alito, I remember in the oral argument where he said it looks like, I mean, he was paraphrasing someone else, but it looks like you take the athlete, you use them up, they get hurt, then you cast them away. And I was like, once he said that, and then Justice
Yeah.
Thomas saying, why don't you cap college coaches' contracts? Now, there was actually already
That would
a
also
case
be illegal.
that would be
Yeah.
illegal. But you can see where his mind is at. And the one justice who was actually sympathetic, I actually thought would have voted for the NCAA. I didn't expect 9-0. Was Justice Breyer, who fairly progressive, and he was actually he was the one saying, "I'm worried about the court getting in here to change rules." If you got one vote at most, that's really tough.
Yeah. FanDuel wants me to give you my picks because I know you're dying to hear my picks in the Super Bowl, but I got to be honest, my picks are kind of awesome, at least a couple of them. But go to FanDuel.com/Staples and sign up. You place a $5 bet. If you win that bet, you get $200 in bonus bets. FanDuel.com/Staples to sign up for that. So they have tons of specials for the Super Bowl, tons of different props. There's one I've been telling you about over and over. And in fact, the line on it has gone down since we started talking about it. I don't think it's because I started talking about it. I think it's just people are looking into the history of the players involved and thinking, all right, this might happen. So I will give you my picks. First of all, right out of the gate, the game itself. Chiefs plus 2.5. I do think the 49ers probably on balance have a better collection of talent. Like Trent Williams is the best offensive tackle in the game. Fred Warner is the best linebacker in the game. Nick Bosa, well, I don't know. Is he the best pass rusher? He probably is the best pass rusher in the game. Christian McCaffrey, probably the best back in the game. Pacheco's pretty damn good too, though. But that said, you're going to give me points and Patrick Mahomes. I do think I'm going to take the points in Patrick Mahomes. So I'll take Chiefs plus 2.5. The other one, any kicker to kick a 60-plus yard field goal. This started out at plus 4,000. This is down to plus 3,500. And as I keep pointing out, Harrison Butker, the Chiefs kicker, has hit a 62-yarder off of grass before. So, but now since that case, and I think it's interesting. I went back and read the Gorsuch opinion the other day because it felt like for years the NCAA was hanging on to a line from the television case back in 1984, which they also lost. It was, University of Oklahoma and Georgia sued them to get the TV rights back from the NCAA. But there was a line in there that said that we want to protect amateur sports. And then Gorsuch just line by line took that out and said, this doesn't apply. You can't use this as a shield anymore.
Yeah, he literally, it's exactly what you just said. He just said, that's irrelevant here. That case was about TV contracts. It has no bearing on college athletes. And the NCAA would repeatedly use that language. And as you said, in a case that they lost, ironically, it was their best case. And here the court said, really just dismissed it quickly to say that's irrelevant. This isn't about TV contracts between schools, conferences in the NCAA, and TV networks. This is about compensation for college athletes, in the Alston case in the form of reimbursement for education related expenses. So for the court to just so quickly and swiftly dismiss it, that had to be jarring for the NCAA. I mean, this was kind of the last decade has been so rough for their legal team, and yeah, I don't know where the window is for them. I think to Charlie Baker's credit, he's at least proposed something that tries to separate certain schools from others. I think that's smart. I don't know if it's going to have any traction. As the NCAA likes to say, it's a membership organization. We'll see what kind of suasion he has.
So let's head to New Hampshire, a place you know very well, where the National Labor Relations Board regional director, I believe in Boston, declared Dartmouth basketball players employees of Dartmouth University, which we have a couple of these going on. There's a USC one going on out in California involving the Pac-12 and the NCAA. But I'm fascinated by this one, Michael, because like the Ivies don't give athletic scholarships. So how are these guys considered employees?
So it's a great question, and I know a lot of people have had it. The regional director, Laura Sachs, said they're employees for several reasons because there's an exchange, and the exchange is basically by going to play basketball at Dartmouth. In exchange, you get to go to Dartmouth. You're put into a preferential admissions pool.
Well, this is the Aunt Becky. This is we saw Aunt Becky serve hard time for this.
Right, right.
The preferential admission part of it is the value. And listen, up in my ad and in my upstairs, I have an acceptance letter to Princeton that would not exist if they didn't want me to play football there. So like getting into this school is the compensation almost.
I mean, it's a huge part of it, right? And not only that, you mentioned there's no athletic scholarships. That could actually work in favor of them. Let's say there's a Dartmouth basketball player who decides to quit after the first semester. That player stays at Dartmouth. They don't lose their aid because it's need-based financial aid. So if they're getting a full ride for need reasons, they continue to have their full ride, and they graduate from Dartmouth, right? It's an elite. They only take 6% of applicants. So, and also the players noted that they also get various things. They get access to facilities, health training that they wouldn't otherwise get. They get sneakers, they get apparel, they get tickets. There was a long line of a list of things that the players noted. So there is compensation in that form, even if it's not an athletic scholarship. At least that's what the regional director found.
And so you've got the USC case, which I thought was interesting. I was watching the coverage of that hearing, and it was they bring in USC officials and say, okay, what are the rules governing the basketball players at USC? And they would pretend that there were no rules, that they're just guidelines. But how much of the control aspect of it is used? Because you had a great paper, and if you guys really want to get into the weeds, in the University of Illinois Law Review, there's a great paper on how all of this came to be. But how much of the control by the entity is part of the test for, is this an employee or not?
Yeah, and thank you for referencing the paper. It was great to work with Mark Edelman and John Holden on it. They were the co-authors. The control is a huge part of it, right? Because compare a college student, and we can all relate to this. When we were in college, we had choice with what courses we're going to take, what we do with our time. And like an employer, a coach has tremendous control over an athlete's time and what courses they can take, even what majors they can pursue depending upon the coursework. So also traveling with the team. I mean, that's a big part of it, that in the middle of the semester when your classmates are taking midterms or turning in assignments, you got to travel across country for a game and miss class. And it really looks like athletics are prioritized over academics. And I think we know that happens. And that's something that judges find very meaningful.
So a lot of that paper and a lot of obviously all of this is kind of leading toward, if they're declared employees, would they form a union? Could they get a collective bargaining agreement like the pro sports have with their ownership groups? And I'm curious, what are kind of the hurdles between this, where they are now, and actually having a CBA in college sports?
Yeah, so there are some hurdles. We don't know what the NLRB board is going to do with this. We know that in Northwestern, the football players initially won at the regional director level, but the board voted 5-0. There's a 5-member board of DC that voted 5-0
Mm.
against them, and they were worried about disrupting labor relations in college sports because the NLRA, the federal law at issue, only governs private employers. So the question is, what
Right.
about public universities? And they're governed by state laws, and state laws are like all over the board
Hmm.
on this issue, and that's a hurdle, just the complexity of it. Another hurdle will be this will wind up in court. This will wind up before a U.S. Court of Appeals and maybe the Supreme Court, and that will take years to play out. So this is not imminent. And another hurdle will be, you mentioned a union. Who's in the union? How many
Right.
unions are there? Are they employees of just the school, or also are the conferences and the NCAA itself, are they joint employers? Will there be CBAs with all of them? And this is something. It was just you asked a question. This is something we talked about in my sports law class yesterday. If you're the football team, do you want other athletes at your school in your union? Uh,
Absolutely not.
Absolutely
I,
not.
I, I
So,
want to keep the value as high as possible.
and how are players going to be paid? Does everyone get paid the same? That doesn't, the quarterback, Caleb Williams, shouldn't he
Right.
get paid more? So there are these distribution questions, and what is the composition of the bargaining unit? These are her. Now, they're not insurmountable, but I don't think we know the answers, and I suspect there's disagreement when we when we take a more granular look at this. I think we'll start to see some daylight that we don't yet see now.
Yeah, and that's the thing. And there's so many questions to be answered, but it does feel like there's some clarity coming in terms of they've got to change the system. But just for those of us who are not lawyers, what is the advantage of a CBA versus a situation where you have a group unilaterally imposing rules?
Yeah, and I know Coach Rick Pitino suggested. I mean, it was a tweet, but that a conference should
Yeah.
put in a salary cap. The problem with that is that it will be subject to antitrust law, and if it's subject to antitrust law, a salary cap is price fixing, so it would be
Yeah.
vulnerable to an antitrust challenge. In contrast, if there's a collective bargaining agreement, anything they come up with that relates to hours, wages, and other working conditions would be exempt from antitrust scrutiny. There's something called the non-statutory labor exemption. Very basically, it represents a group of Supreme Court cases that say, in so many words, look, we want to incentivize management to bargain rules with unions. And as
Hmm.
a result, when they do that, we take antitrust law and the risk of treble damages and all of the scary features of antitrust law off the board. So that's the advantage. If all college athletes were employees in a union, college sports would be saved in the sense that they could just negotiate rules with their schools, conferences, and the NCAA. Of course, that's the world the NCAA doesn't want, but yet it's the one that might actually cure its headaches.
Yeah, it's crazy. I wrote it in SI during the Northwestern case. I was like, there will be a time when you beg them to unionize, and they're still not begging them, but I do feel like it might be their only shot because, yeah, like you said, if you have a collective bargaining agreement and someone were to try to sue, the court's just going to say, well, you guys agreed to this,
Yep,
so go back to the
that's it.
table, go to arbitration. Like, no, you've agreed to this.
It's the greatest defense, right? The other side agreed to this contractually, so you
Yeah.
can't now argue over it. And look, and I know, so what we just described makes sense for like these top football programs and some top basketball programs. For a lot of schools, it's scary, right?
Yeah.
Because they're not making money, or they're, if you look at at least their accounting, they're going to suggest we can't have everyone be an employee. We're not going to be able to afford it. Our revenue model is different. So for those schools, they have to, in a way, it would be good for the top athletes to be employees at the top schools, because
Right.
then you can distinguish them, right? You can say, okay,
Yeah.
that kid is clearly an employee, but at our school, the swimmer, the field hockey player, the even the baseball player, that they're not really an employee in that context. But it's tough to get there, and the NCAA, by fighting and fighting and fighting, this is the problem playing defense all the time, right? We know prevent defense doesn't work, and that's what the NCAA has been playing, and it collapses eventually, as we know from sports.
And probably too late to hire a new offensive coordinator to juice the system. So
That's
it's
right.
and they're also out of money, I think, at this point. So Michael, thank you so much. This has been very educational, and I truly appreciate it. And hopefully you can get to covering the other sports eventually. But thank you for keeping us educated here.
Well, Andy, thanks for having me. It's great to see you, and let's do something again soon.
Yes, sir. Thank you so much for watching. Just a reminder, subscribe to this channel right here so you never miss an episode of Andy Staples on 3. And oh, by the way, watch all the other great videos on the On3 Sports YouTube channel.